Yes. Where a person makes a will that in case if I am in coma or something, don't put me on ventilator, etc. My lords were pleased to long back issue certain directions, and it was the case of Mr. Datta that they are not workable. Thereafter, your lordship would recall last time we agreed that we'll have a joint meeting. But we had a joint meeting. The secretary and other senior level officials, who some of them were doctors also,
DGHS also.
DGHS and everybody, my lord, were there in the meeting. It was a very positive meeting where we also agreed that some of the steps which are stipulated are not workable. That we also agreed with Mr. Datta's contention. Now we have two models before us. One is, my lord, given by Mr. Datta. Another is the model prepared by the AIMS, Delhi. Delhi. So, my lord, there needs to be some consultation at our end with some experts. We'll sit again and we will find out, my lord, some common.
Yes, but we had a meeting, briefly, as the solicitor says, this question of signing it before the judicial magistrate after 3 panels of doctors, it is not going to work. I mean, in a practical situation, in Madras or Bombay, nobody is going to get the judicial magistrate to be there and after 3 panels of doctors. So we have agreed. Now, what they are saying is the health secretary and the DGH will go through we are given a flow chart. What could be a simple way of solving it? They have
Finally, what are you suggesting?
Finally, I'm suggesting, Lordship, will have it in January. So we'll again sit together over the December, because I think now only hardly time is left. There may not be time now.
No difficulty.
No, my learned friend would agree. We are not, my lord, meeting. Lord, we are not meeting in an adversarial. My lord,
Yes,
friend would agree.
I was just suggesting for Lordship's kind convenience. My Lord has posted the WhatsApp matter constitution bench in January. If it can be put on that day, because the bench may not sit on a daily basis.
That's right.
Your lord,
Anyone
may not have to.
We can put it on that day.
Yes.
I do the item number?
3, my lord.
503.
503. I'm sorry, 50.
Solicitor General.
You should get what there is a consultation going on between.
Yes, we are saying just answer. Learned Solicitor General and Sri Ashwin Datta, who appear for the respective parties, will point out that pursuant to the earlier order dated so and so. Order dated. What is it? So there is an order. There is an order.
Overlord.
There is an order.
That we meet together.
Earlier order. Just take the time. Last day it came. Efforts have been undertaken. At present, the matter is engaging the attention of the AIMS.
No. The central government.
Ministry of Health.
Ministry of Health.
Union of India.
Union of India. Some more time may be required.
So that we will, what we are thinking is, if we both can come to some consensus,
That
we
can be
place the guidelines before the
Exactly.
court.
We will not trouble your lordship. We can assist your lordships for your lordships approve.
And then your lordship will modify it or whatever.
Yes.
We are completely at item. We are the original petitioners. The common cause.
Original petition.
Original petitioners on
But
whom
you will also be, we'll be hearing.
we are completely at item with the critical care doctors. We feel that those directions are very cumbersome.
That's right.
Need to be simplified.
We also heard, you can see Sri Prashant Bhushan.
Me and Mr.
Lord,
Bhushan
and
are
one-
also add item in this.
That's right.
In bold letters.
We are
All parties are either.
yes.
Only one request, one request. If Dr. Kishore is here. He was involved in drafting the Organ Transplant Act, and his books and articles have been referred to by Honorable Justice Deepak Krishna and other people. So he has got a lot of material. There's a difference between terminal illness and incurable illness. So what is death? So there are legislations of Oregon, etc., which we all consider. So he also wanted to say a few words. Lordship may subject to my lord's. At that time, we'll see in January.
That time we'll hear it. Not today. Sorry? Last sentence. As also Sri Prashant Bhushan appeared to be an item that further efforts may have to be made to arrive at suitable guidelines,
Draft guideline.
because
which can be placed before
yes, before it becomes guidelines only after your lordships approve.
Correct.
The lordships may modify.
Placed before this court for consideration of this court. Matter will stand the step to that day on which the other
I
matter.
think it's 17th January or 23rd January.
17th.
17th.
17th January.
That WhatsApp date not so.
That's right. So that's over.
Lord, I want to make a submission. I'm a medical field diversified into law. I was a doctor for 40 years.
Which side, which medicine
Dr.
side
Kishore.
you are?
I am Dr. R.R. Kishore.
No. What's your specialization?
Your specialization.
I am a radiologist.
You're a
I was
radiologist.
a physician for
Are
30
you
years.
specialized in
Then I
radiology?
specialized in radiology.
Are you specialized in any particular
Yes,
branch?
I
Are you general radiologist or a?
am a radiodiagnostician.
That's right. We follow
And
that.
I'm an oncologist also.
Also.
Now
I
I'm
agree.
a member of the bar since 2004.
Yeah.
I have worked in this area of end to life, right to life for a quarter of a century. And many of my articles have appeared in leading
Yes.
international journals.
Very good. Yes.
When the Honorable Justice Deepak Mishra was heading that bench, he requested me to assist the
Correct.
court. And my articles have been referred in the judgment itself.
Yeah.
So I would like to be associated with the
What do you want? We have actually,
Yes.
So my name may be mentioned in the order so that I may be a part of this exercise of debating this entire.
But he has done a lot of work. He's gone to different.
He will be associated.
Let it come in January.
No formal this.
also heard. So
Dr. R.R. Kishore.
RF Kishore. We also heard. You can just put it that.
But I would, my lord, ensure that he is also participating.
Absolutely. This is
No,
not
I was very
adversarial.
part of this is
As you pointed out, this is not adversarial.
no. And my lord, the officers were also my lord, very, very cordial and very positive.
Very good. In
And
fact,
now it-
there are also safeguards in organ donation. That also, so we are trying to put in those safeguards.
Very good.
Yes.
Very good.
Obliged to.
501.
Your Lordship.
So we are just keeping in mind the time limit because we propose to start the
I-
Kalika too. We are not imposing. We never.
No. I understand. I mean, some of those peripheral areas sometimes assume some importance that we have to address them.
Go ahead. Please go ahead.
Right. So, Elosh kindly pick up this information.
Yeah.
This is with reference to what Elosh has shared with us yesterday. We now have a complete picture on this. Now, if you look, before I take a loss with that, one broad statement I would like to make before I take a losses to this.
Yeah.
Now, I would probably call 1991 when the Act was enacted. Post 1990, Dinesh Goswami's report.
That's right.
Your Act put in position.
That's right.
Prior to that, there was 1972, 1989. There was some legislation.
Correct.
So I would probably call 1991 a watershed. The period prior to it may have a different circumstances, environments, compulsions, needs, and the country moving towards a civilization of the democratic and electoral process. The Dinesh Goswami's report comes, and thereafter, if Parliament has applied its mind and has gone in a certain direction, then the question that would arise is, post 1991, we are not going back anterior to 1991, therefore post 1991, even after application of mine to the Parliament, the law coming into position, whether that law has failed in its object of ensuring the independence of the election body.
Which law?
1991 Act.
1991 Act is traceable only to 224(5).
That's true. After Dinesh Goswami's report. That is the 1990.
True. But we are saying, see, 1991 Act, if you have that Act,
Yes, yes.
you'll see from the very long title, it speaks about terms and the conditions of service.
That's right.
It doesn't deal with appointment.
I'm aware of that.
Term.
I'm aware of that. But the conditions of service, namely a tenure, remuneration. Like in the context of independence of judiciary, these are two fundamental conditions. So these two conditions may run across many of the institutions where an independence is to be secured. If these two basic conditions are put in position, a third condition or a fourth condition may or may not be strictly necessary for the purpose of ensuring independence, unless the court has to travel further that any one of those additional conditions are so indispensable. So that is the additional factor the court may have to look into. So where assume the court or even Parliament thinks it is indispensable, but doesn't rule on that. The next stage will be this indispensability having not been addressed. Is there in a given case, in a given circumstance, in a given case, is there a matter for consideration and a matter for concern? So if there is no such circumstance or a case where a third or a fourth and additional condition would have made a difference and would have added to the security and independence, etc., that's how the court would probably go into it. I thought I'll flag that like that. Therefore, these two conditions, the security and remuneration, are taken care of. And as long as they are taken care of, it's only in a given situation when there is any other aspect of a matter, which would be a matter for alarm, a matter of a concern, and there is an abuse of a position, process, etc., then the court may enter into it. I find that
straight away we will flag two issues there.
Yes.
See, you appoint a yes man. Just going to the
Yes. I'm only
just giving the example.
Yeah, Lord.
Not that we are suggesting that you're doing it. You as a government, any government,
Yes.
for that matter, it appoints a yes man. Somebody carefully picks him up. Somebody who is like-minded, has an affinity of thought, their philosophy. So they will do their, whatever they're building, they will do it. They know it.
No, Your Lordship, sir.
You take him. You assure him security. You assure him both the other thing under the surface proviso 324(5), namely his conditions. On the face of it, everything is fine. Dolly. So perfect independence is what is the quality which is lacking?
Absolutely. I mean,
The quality which is lacking
absolutely
goes to the core of the matter, which is whether the man is really independent. See, there are various virtues, like in the American statute. It speaks separately of an amalgam of various virtues, one of which is independence. The most important thing is independence for certain institutions. You don't require that independence for a member of the parliament secretary. You don't require quality. See, the qualities of various qualities are to be judged with reference to the post that a person knows. For example, judge is supposed to be independent. I may be the most competent person. I know everything. But if I am docile, if before the government I become weak-kneed, when I have to take a stand, when I will risk my life, if it is so, then it is that quality which is required.
Quite right. Let me try to further expand on that.
There it is important.
Absolutely. I mean, all these are aspects which will definitely go into not only a thought process, but also in their application. I quite see that. I'm not saying disagreeing with that. But why I thought I'll flag it is that the question of pick and choose or appointing a person of what some Justice Frankfurter called spaghetti spine. So we are not, therefore, if there is a room for doing that, and if there's an actual occasion when it has happened like that, then the court may enter into the picture. Why did it happen like this? How is it happening? The occasion for examining that issue will then arise. So, on a premise that because that additional third or factor is absent on a premise, there is every possibility of a yes man being chosen, or somebody, again, to use the same expression, a spaghetti is fine person being chosen. That will arise only if there is an actual demonstration in a given case. So, for the court to probably say that we have an experience, I'll presently show what's happening in Pakistan. So, we'll have an experience, despite the best of models, if something else is happening, then you're looking at the experience, not merely at the model. And we look at both at the model and the experience together. That's how I think the court would probably look at it. Therefore, I want to flag that post-1991, and particularly in these batch of cases, I am not able to find anywhere a trigger point which could be said to be an alarming situation where the act has been subverted or the process has been subverted for the purpose of picking up a person who would be an abiding, who will abdicate his office and so on and so forth. I don't see anything in any of these petitions. The broad speech of the petition is, here are a set of reports. These reports come under acceptance. We don't see why they are not being looked into. High-level bodies, law commission reports, I think they should deserve acceptance, therefore look into them. Therefore, it's very important that there is somewhere in several, while we certainly articulate the role of the court in important fundamental rights violation cases, but certain other areas where the role of the court would be certainly important for the purpose of looking at various policy measures. Look at today's, we are not even saying that because of global impact and a variety of aspects, the governance issue is so complex. So, therefore, keeping all that in mind, the court's intervention in very important areas of governance would certainly be welcome. And they may add to the quality of governance. That's how the court plays a role. And I don't think an attorney can say no to that. I'm very clear on that. But I only want to say this line which will be drawn by the court when the trigger point is very important. If the trigger point is not there, for instance, the Anjali Bharadwaj case, the right to information office, there was a trigger point. Vacancies were there. Appointments are not being made. So if there is a good trigger point, and that will certainly arouse the anxiety and concern of the court. And that then have a duty to assist the court in the best manner possible. But I say there is no trigger point in this case. Now let me take your lordship to this sheet of paper. If we look at in the date of birth column, we just go through that. It is invariably on the basis of seniority of a civil servant. Except, for instance, in serial number 14, there was one solitary instance when 14 and 15. So, Mr. Anup Chandra Pandey, 59 cadre, came to appointed later, person appointed earlier. That's the only one solitary instance. That could be for a variety of reasons. We need not to guess on why it has happened. Then coming to the tenure as election commissioners, Krishnamurthy from January 2000 to 2004 as election commissioner, then an elevation from February 2004 to 2005 when he attained the age of 65 years. So he had a tenure of 5 years, so and so, in the election body. So we are looking at the total tenure of a person in the election body, not merely as chief election commissioner. Because the body is composed of election commissioners and later on being elevated as chief election commissioners, we are looking at a composite body as a whole. So you'll also find therefore in every almost except 2 or 3 cases, again looking at the case of serial number 6, 7 and 8, Mr. Sampath had a tenure of 5 years, 8 months, virtually bordering on 6 years. Now the rest, then Mr. Sampath, Brahma and Mr. Nazim Zaidi, they all were appointed during the earlier governmental period, and they continued after this government was voted to power. Therefore, there is no interference as far as the security of tenure is concerned. Then I will look at, for instance, those cases where a 2 year, 3 year, 2 years, etc. They're all cases where they were reaching the age of 65 years. So one could say why you can't choose somebody who may have a 5-year, 6-year tenure. That could be one matter for consideration. Perhaps it all depends on which is the best possible person who reached a particular stage in the civil service career. How do you pick them up? So there is some element of locating the best ideal possible, I think, must have gone into this. So unless, again, as I said, in a given case, this particular location of this
For
person
example, how did you
is
appoint,
wrong.
Sunil Arora at serial number 11.
Your Worship, please, sir.
He is appointed in 31/8/2017.
11.
31/8/2017.
Yes.
He served for 1 year and 4 months as election commissioner. Then he takes over as the chief election commissioner from 18 to for 3 years.
3 years.
So here it is slightly different. He gets a longer term.
That's right. So these permutations and combinations may not necessarily lead to a conclusion that there is a tenurial insecurity.
Not insecurity. You have, yes.
Or even put it the other way, that this tenure is being handled in such a way that you have a person who would probably say, I don't think those considerations.
A person who's appointed as an election commissioner, does he necessarily have to become the chief? Is it a promotion? What is it? Does he automatically become?
On elevation, on seniority.
So on seniority. So is it laid down? Is it something which you follow?
No, there is no discretion there. On seniority, you get elevated.
You get elevated.
Yes. You become a chief election commissioner.
There is no elevation.
I mean, I'm using the word in a good sense.
After what you meant is, see, after the judgment in Sessions case,
yes,
where he said that actually this first among the Noah case, that is the first judgment of Justice Savan, where Lordship
Danoa.
That is, the chief election commissioner is not even the first among equals because he's on a different higher pedestal.
Yes.
So that theory was actually sort of demolished in Sessions case.
Session has
They are equal. So when you actually went from a position of equality, when you move, you don't move vertically. Where is the question of it being elevated, or what do you mean by this process? And what is the process of appointment? Would say the only traced to 324(2). So are you then hidebound? Whenever somebody is there as an election commissioner, it becomes his legal or a constitutional or whatever right it is to become the chief election commissioner. So would you then be rewarding somebody with, say, for example, inefficiency, with somebody who is mediocre? Then do you?
No, then comes.
Yeah, just.
I understand that. I understand that. I mean, those considerations again will certainly guide. But if you have to make it either flexible or inflexible, Lordship knows in every institution, flexibility sometimes adds a certain strength. Sometimes inflexibility impedes. Therefore, if you want to have a greater amount of flexibility, overlooking a person who might have been shown to be inefficient, then they become subjective factors get into them.
So then there is another problem. The moment you pick up somebody as election commissioner, now he is the person whom you're targeting to be the chief election commissioner as well. It's all rolled up. In other words,
that's true. That is true. That's why I was trying to look at this. I tried to find out what best one can draw from.
Take the Constitution. Constitution to each one of us.
One more thing, when you said,
I'm sorry.
one more thing, when you said that it is by virtue of seniority,
Yeah.
then only one doubt.
Yeah, Lordship.
See, a person while working as an election commissioner,
Yeah.
is not having that kind of an immunity in the matter of removal. But automatically when he reaches the other post, he is having that immunity. Because in the case of a Supreme Court judge, only after following such procedures, he can be removed. So that means, now, what is the basis for them? Because as
they're all inbuilt.
if they are equals,
no difficulty at all. There are inbuilt principles that are conveyed. Therefore, if an inbuilt principle that the security of tenure is there, is implied, you don't need to look at it expressly. Therefore, in a given case where an inbuilt principle is violated or breached, then comes the question of why are you doing it? And have we done that? Therefore, I don't think we. Your Lordship, please. I'm sorry.
Our request is please take instructions again.
Yeah.
We are recording your statement that after the election commission's appointments are made,
Yes.
that senior among the two is being appointed as a chief election commissioner. It is your statement. Please take instructions. We'll record it. And if you are making election commissioner as a chief election commissioner, what is the guiding factor according to you in making an appointment? Only seniority among the two?
Yes, seniority. That's what we are on.
Seniority.
That's how it is.
All right. And what is the mechanism in appointing election commissioners?
So that is again a procedure which has been followed over a period of time. There's a convention. You
What
have.
convention?
I'll just come to it. I'll just explain.
Because if the entry level is in your system is election commissioner, and only the election commissioner become a chief election commissioner.
Right.
So there is no independent mechanism available to consider other than the one who is not election commissioner.
Then comes the question.
So you confine to election commissioners alone
Quite right.
for the purpose of appointment of the election commissioner. And that man has already served
Yes.
into this election commission's business for 2 years, 3 years, whatever the role is. As and when the vacancy of election commissioner is available, then only do one thing. Show us what is the mechanism you put in place for the purpose of your entry level as election commissioner.
Yes.
If this is your stand, so we don't want to go ahead open selection process for a chief election commissioner because the entry level is election commissioner. Make it clear. Make it
The entry
clear.
level is election commissioner, but there is no direct appointment as the chief election commissioner.
There is no bar here.
That is the position.
In fact, that was what was being done for 40 years.
Exactly.
That was the concern of session. The concern of session was that you are really eating into the sort of independence of the chief election commissioner. You are corroding the independence by this process of having 2 election commissioners.
No, and that's why
That was the whole idea.
whatever
But that
session,
was-
TN session, pre-TN session era is now a closed
That's
chapter.
it, 40 years.
Is now a closed chapter. Now, a lot of lessons have been learned. I'm sure the lessons have been learned from our side. I don't think that needs to be a matter of concern. That I think
The point.
I also looked at
The point therefore.
Your Lordship.
The point therefore will be, if this is your submission, the process, procedure that we may consider putting in place will have to relate to the appointment of the election commissioner. The reason
I see that. But
if
there may be
if he is going to go up the ladder automatically in terms of seniority, the appointment must be scanned at the stage of the election commissioner, not the election commissioner. The prayer will have to be changed.
No, I try to visualize how best a legal framework put into position in 1991 would be put into place, and in order that the executive gives an assurance that there is no playing with the law. How best one looks at it. Therefore, how many rules, do's and don'ts will you bring into a body like this, an appointment? So how can it be compared to any other bodies and institutions under the Constitution? So I don't think a mechanical comparison, even sometimes broad comparisons may work. Some institutions may just look at it in isolation. Therefore, it's important for us that as long as the bottom line is, if there is a scope, suppose somebody has challenged this 1991 Act and looked at the circumstances when there has been some element of deviation, breach, abuse, then the court would occasion to see why, what are you doing? How is it being done? My only difficulty is since none of those dimensions have been presented to the court and there is no such aspect to do before the court. The anxiety and the concern is how best we can suggest something so that whatever is not seen, whatever is not perceived, right, by the court or by us or by the citizens, why don't we look at it and see if something can be added? That's where I think the court's concern seems to come in, if I am not wrong on that. So I was just looking at this figure and to find out if this figure does not demonstrate, does not show that the 1991 Act or even 324(2), the repository of constitutional power, has been exposed to any abuse, then perhaps the court will be very slow to go beyond that. Very slow to go beyond that. And I wanted to show how, for instance, the next sheet of paper. So we have the Pakistan model where there is a consultative process. And there is either a judge of the Supreme Court or a judge of the High Court is to be. So despite all that consultative process, kindly look at this scenario. The total time There are people who have spent 49 days.
1 month.
So it may depend on when a person is chosen. And there are persons with 1 month, serial number 13, 14, they're all 1 month.
Lot of judges.
So I
I
didn't
think
want
most of them are judges.
why I wanted to bring this comparison is there is a different model there, a consultative process. You have an element of a person who held the office of a judge of a Supreme Court or High Court. So even in that consultative model, if persons with tenures of service which can be as low as this, then it is not merely the model, it is the actual working of the model. So therefore, merely to suggest there is an ideal model elsewhere, you borrow it, would be a very weak proposition to be suggested. Would be a very weak proposition. And those models, as we saw, Canadian model was considered by the Constitutional Assembly. The South African model came much later in 1996 when the South African Constitution came in. For what reason they have a consultative model? The apartheid, the entire history of South Africa, which needed a complete paradigm shift in governance. Or take a country like Albania much later, or countries in Europe or in Asia, South America, where you have fragile democracies. So in those fragile democracies, we pick up a model may be good, but democracies do not work. Therefore, say a mere model elsewhere as a constitutional model, except supported by good experience. In the absence of a good experience, a model by itself will not be suggestive of a great change and an important change from the current disposition.
Attorney General, at the end of the day, what they are suggesting is perhaps not as ambitious as you are apprehensive of. What they are suggesting is only fill in that perceived vacuum.
Yes.
I to the extent of having not this council of ministers, picking up somebody and then doing it. Just have the Chief Justice, for example, of India, who's credentials.
Absolutely, I'm nothing to disagree on that. I quite see that, but
once you have that,
yes,
that is the only area that we can possibly come in. We also are conscious of it. We can't be obviously making an invasion on the Constitution.
Certainly.
Constitution has to be respected. That's why we have a constitutional court.
Absolutely.
So we have to do that. That is the only area. You need only sort of concentrate on that.
Whatever falls from the constitutional court is a matter of great deference. I think it must be received with utmost sincerity and that.
That's all that we are suggesting.
Yes,
Not that we'll have complete takeover of your. We can't do that because it's a constitutional government. It's the Westminster model where it's a cabinet advising and actions are taken by the president in accordance with that. And we know that.
No, I'm not
saying that there is a small gap in the sense that in view of the number of reports which have spoken in one voice. Political parties spokesperson have spoken in one voice.
Yes.
Because they know on the ground, reality. Like you said, the model is there, but how is it acting on the ground? How is it being used by the politicians on the ground? Irrespective of whichever party they may belong to. That calls for reform. Now, whether, as you said, reform, we should wait for Parliament to wake up and see the need, which is very unlikely for the reason, very good reason, that we told you yesterday. Each political party in power would like to perpetuate itself in power. So they'll put it off. Okay, let the next government do it.
Right.
We got a good man. We are sort of having a very good relationship with him. He'll do our bidding. Things are moving fine. So nobody wants to walk that extra mile to bring in the much needed changes. That is the only area where the court may have to step in.
I wouldn't, in principle, disagree with that proposition because I think that's how we assist the court, and how do we reach that if there is a point for reaching? Certainly, that's how we assist the court. I certainly no disagreement on that. But to have that concern repeatedly being brought about, there could be shifts in the nature of governance and quality of governance. And then very often, I would probably put it like this. I may just take your lodge to a supplementary note which I have prepared and then take and try to proceed further in order to save the court's time. And as your lordship seen in that sheet of paper about this, they're all, before I read that, in this, may I draw your lord's attention to the sheet of paper once again?
Yeah.
The details of tenure of election commissioners, etc. They're all people at the secretary level. People who reach in secretary level, and there's nothing like going down below to pick and choose. The importance is the length of experience people might have had over a period of time. And you lordships know that a district magistrate is an appointment to the collector, is a returning officer, and then they become electoral commissioners at the state level. So they gather this experience about election matters over a period of time. They might have thereafter been disposed to some other positions are there in central government or even state government. Many of them have become chief secretaries, they worked as an important position. Therefore, in principle, highest level of secretaries, chief secretaries, retired officers, they are all considered for the purpose of the appointment of the election commissioners and chief election commissioners thereafter. Therefore, there is hardly any occasion when there has been a shift from this convention. The convention is scrupulously followed. And that's a very important aspect to be kept in. Now, let me take your lordship to this. I will also give it to the floor. Every person was right from yesterday. Your lordship talked about Sukumar Sen onwards, Nagendra Singh. So the background profile of each one of them, I thought I'll place it on record so that
even,
the court has I will not currently trouble your lordship into.
And even while you say that with respect, after going through this,
Yeah.
that all these persons were actually functioned at the secretary level, but it would be indicative of one fact. Now, all along you were only looking into the bureaucrats for this post.
Correct, they're all civil servants. Civil servants who reach the level of a secretary of a department. So
All along only.
Now let me take your lordship to my note, supplementary note.
Yeah.
No case has been made out on facts, namely materials to show that the appointment of a chief election commissioner or the election commissioner so far, subsequent to the Election Commission Zones Act of 1991, are open to question by reason of extraneous factors or abuse of process. There is nothing to show that the independence of the Election Commission has been compromised by reason of the appointment process. As already explained, the focus of the report of the Committee on Electoral Reforms is as contained in para 1.6. Item number 2, referring to the strengthening the Election Commission and securing its independence, is not premised on any materials regarding concerns relating to the independence of the Election Commission. However, the recommendations towards securing independent election commissioner contained in paras 1.1, 2.2, 2.4, and 2.5. These recommendations now find their place in the 1991 Act as well. As far as suggestion contained in para 1.2 regarding mode of appointment, it's a shift from the position obtaining under Article 324(2) of the Constitution. And that's a matter entirely for the executive to consider, taking into account the compulsions, if any, to switch over to the mode so suggested. On this aspect of the matter, if it is respectfully submitted, there cannot be a positive direction directing the executive to proceed to act in terms of the recommendation. Then Chapter 6 of the report number 255, the Law Commission dealing with the subject of strengthening the Election Commission of India, takes note of the Goswami Committee report and after a brief reference to positions obtained in certain other countries, proceeds to issue recommendation para 6.12.1. The Commission adapts the Goswami Committee model with certain modifications, as may be found in para 6.12.2. The premise set out in para 6.12.1 that executive interference can imperil the neutrality of the Election Commission is not based on any material, but is purely propositional. As far as the recommendation in para 12.6.3 is concerned, it will be placed on record that the elevation of Election Commission, using the word very decidedly, as Chief Election Commissioner is in the base of seniority. Therefore, it's clear that none of the reports relating to electoral reforms which suggest alternate modes of appointment of the Election Commissioner promise any material discussion that the current constitutional scheme under Article 324(2) has in any material way affected the independence of the Election Commission. Neither is the 1991 Act under challenge, nor is working, nor have any instances of improper appointments under challenge based on relevant materials. In such a situation, the question of entering into any critical evaluation of the working of Article 324(2) or the inadequacy of the 1991 Act does not arise. None of the serious compulsions for the need for the court's intervention, as discussed in paragraphs 26 to 29 of Vineet Narayan, are found in the present case. By convention, it's been established that the members of the senior civil service or those serving retired officer the rank of Secretary to Government of India, Chief Secretary of State Governments have been appointed election commissioners, and senior most election commissioner, the Chief Election Commissioner, on the basis of database maintained by DOPT. A list of serving and retired officers in the position of Secretary to Government of India, Chief Secretary, is prepared. On this basis, the panel of names is then prepared for the consideration of the Prime Minister and the President. Prime Minister, after considering the panel of names, recommends one name to the President of India. A note with the recommendation is submitted to the President of India. That's how the system works. The Election Commission of India, as it is now functional, is fully independent. It acts entirely in terms of the relevant statutes relating to election and ensures the integrity of the electoral process. Once the electoral process is set in motion, every aspect of the process is regulated by law and is not amenable to any intervention by any external agency. The Election Commission of India enjoys a great amount of international reputation with regards to the role in the conduct of elections in India. I place and record a series of MOUs with the Election Commission of India has entered into. There is a UN model, and based on that model, about 33 countries have entered into MOUs. At the cost of repetition, it is submitted that it would be too wide of the mark to compare the fact situation beneath Narayan and conclusions drawn therein with the instant case. Comparisons merely on the basis of considerations of anxieties expressed regarding insulation of criminal investigative agencies will be inappropriate. The position of obtaining of the 1991 Act shows the Election Commission is independent in all respects and time-tested conventions as regard the appointment of election commissioners and the elevation of Chief Election Commissioner are in place without any room for complaints regarding independence being compromised. Therefore, submitted there is no room whatsoever for a second look at other model schemes obtained elsewhere. It is submitted that only in case of demonstrated circumstance of fundamental rights infringements can there be an imperative for judicial intervention for enabling, facilitating, or effectuating fundamental rights. This case presents no such urgency or imperative. General debates touching upon constitutional changes or proposition, howsoever desirable, deserve to be relegated to other domains of discourse. Before I proceed further on showing some judgments in
Mr. Attorney, let us see the Act of 91, how it demonstrates a reference to appointment.
Yes, Your Honor.
Because I don't find anywhere regarding the mechanism in appointment.
No, it is not here.
Then
I'm not saying it's here. Nobody says it's here.
your statement is read this paragraph.
I said that's a convention.
No.
That's a convention.
Please, read paragraph 10 of this letter which you give to us.
Your Lordship, please.
Read it.
That's right.
What kind of independence you're asking in 91 Act? There's nothing.
No, the
91 Act only deals with what will be their term, what will be their pay structure, what will be their pension. That's all.
Then the question would
We are on the entry level. We are not at the level as to what will be the term and conditions of his service after he is inducted.
Wait, right.
We are referring to how the induction has to take place. That has nothing to do with that 91 Act.
The point would then be, then the 1991 Act does not touch this subject.
Correct.
Right. If it doesn't touch the subject, the 1991 Act is unconstitutional.
No.
It affects the independence of Election Commission. Therefore, something which is outside, to say, either we say the 1991 Act is silent on the subject, and because of its silence,
Show us from 91
and because
Act.
of its silence, there is.
Please show us from the Act of 91. What is the mechanism in place for the purpose of appointment? You don't
Nobody says the 91 Act contains that mechanism. That is
What kind of independence you're asking for in 91 Act? 91 Act only says term of appointment will be this, salary will be this, pension will be this. That's all.
No, let me come back to Lordship. What are those aspects which will qualify as independence of an institution? We must look at them. That's why I said in the beginning, tenure, remuneration, and maybe any other second, third, fourth additional factor. So if the 1991 Act does not address those second, third or fourth additional aspects, the Act may be found to be wanting. But to say because there is a position obtaining outside the Act will not be in conformity with the independence of the institution may be yet another step. So therefore, we are not looking at the inadequacies of this law, unless the court had to say, oh, the law should have addressed that also. That's precisely what we're now talking about, in a different way, in an indirect way. We are saying...
We are not saying that.
No.
We are saying none of the statutory instruments lay down that procedure.
Your Lordship, please.
We are kind of looking at the manner in which you are appointing and whether the manner of that appointment
Inspires confidence.
can put in a person
Correct.
in that post who can act or who would be an independent person.
How do we really test that proposition? Either the court says on an analysis, on a demonstrated basis of faults, crevices, and defects in the appointment process, then comes, look here, whether it's not part of a law or not, it does not make a difference. Your practice, your experience shows us that you are... We are now not looking at the law. We are now going back to a stage where we have a series of recommendations which said there must be a consultation process, there must be this, etc. Suggestions are given. Inclusion of some dignitaries would be high placed and would be probably make a difference. There are all those propositions and good suggestions. So the 1991 Act, which came after Goswami's report, has probably kept them aside, let's say, for whatever reason. Or thereafter Parliament, that was the early occasion when Goswami report was taken into account, Parliament applied its mind. And thereafter, if the Parliament or the government did not find that the reason to depart from a convention which is being followed, and which according to the executive and the Parliament could have doubted it. At no point of time, any doubts regarding the convention or the practice have been raised either in the Parliament saying, look, what are you doing? We have now reports and information to have a debate on this issue. So we find your convention is not convincing at all. We must depart from that convention. So we don't have any one of those situations which may warrant or a trigger, I said, a re-look into the whole issue.
Yes.
So there is a convention which is certainly not part of the law, but it's a convention. So there are lots of conventions which enter into decision-making process at several institutional levels, including appointment of judges. So there is, for instance, several matters settled inside, on a certain understanding of, how. Therefore, one need not get into all those things.
So the convention is that there are convention and that too time-tested convention.
That's right. That is
the convention.
Just
whether there is any memorandum of procedure which you are following. My
in internal arrangement.
also asked that question.
That's right.
There is no material. I mean,
That's
they're basically following the rules of business. The matter is placed before the president and the prime minister. Notice prepared, cabinet decides it, and is appointed.
So there is
That
the Lordship's note. I think in certain areas of institutional governance, a certain element of informality will always be necessary. And as many rules and guidelines you stuff into the institutional governance, there can be problems. So the informality is a very important process. But under the guise of informality, there should not be a scope for an abuse. That's all. That's the only bottom line.
All right.
That's the only bottom line. And if that is not perceived, then perhaps the court would say hands off.
Now, what do you say about the other argument that to insulate the CEC from financial vulnerability, you need to have, and also staff, that it should have a secretary. Is that not a matter where, because we are discussing, it's all very well for us to discuss independence.
Right.
So true independence will come only when they have the wherewithal in terms of staff, materials, finance, to carry out their daunting task. So what do you say about that? What is standing in the way of, giving them, like Sheshan said, that 1.5 lakhs for a, for a candidate? We have, of course, gone past that stage.
No.
But
These
it's a matter, I think, where which you should not be happy.
I don't have many things to say on that, but as long as the election commission has said something on that subject, and I'm sure that must receive weighty consideration with the government. I don't think, but I won't be in a position to offer any comments on it. But institution will serve better if it is all the necessary infrastructure.
Autonomy.
A court without, for instance, today in the digital age, a various physical space is not a court. Understand all that. So therefore, infrastructure. But then the question of shifting to from a charge fund to a consolidated fund and then bringing up all those things will be a matter for again a serious parliament, because consolidated fund, what would constitute, what would be charge fund, they're all basic part of a constitutional framework.
The matter of policy. Right.
So
then what about extending the irremovability clause to the election commissioners, which is another argument which you have raised. Now the chief election commissioner alone cannot be. Now we have a different scenario also, because now you admit now the journey of the chief election commissioner marks its beginning as an election commissioner. So the election commissioners have become perhaps as equal after Sessions case also, that they have become a permanent sort of structure now. Because you had that 90
right.
First you
Right.
brought out the notification, then threw it out, then now it has come to stay.
Right.
Now it is a multi-team.
That's right.
Multi-member. So the election commissioners are as important, because what the reasoning of
As the chief election.
That's right. So Justice Ahmadi's reasoning in the other case was the tenure, because it's actually got to do with the tenure. Because no election commissioner can say that he will have a right to, particular period. I mean, in the sense that if any, election commissioners, if any. But now that if any is gone.
Gone. That's gone.
It is gone now.
That's gone. And for good.
It's gone for good.
That's right.
Because you are saying it's seniority.
That's right.
So that is so, why not apply the same principle that, they can't be impeached? Because they are doing the same job as the chief election commissioner.
They can't be.
Secondly, they are in line for becoming CEC. So all these reasons put together should not be conferred, clothed with that kind of protection. Is the argument.
I slightly digressing.
In fact, writ petition civil 1043 2017. This is my petition and Gopal is arguing.
Mr. Upadhyay.
Yes, madam.
I have some
without your robe and
the
band.
petition.
No, I am not arguing. In fact, Gopal is in other court. Other Gopal is arguing.
As a client, if you come.
Let him argue. Go.
Yes.
I didn't want
So
any adversarial contest here. So it's at a different level, but I may have something to say about the contents of the. You'll also know the famous Brandeis brief. Yes, Louis Brandeis and Mullen versus Oregon. That famous case where Brandeis prepared a brief in support of a
Social.
That's right. Weekly, working hours for women. But then
have to be given.
you lost right. It went into 100 pages, only 2 pages devoted to legal arguments, 100 pages of scientific material.
That worked actually.
Etc. Therefore, which added later, even though this was refuted in its scientific accuracy, different question. So we must have a credible set of information, in fact, on a petition like this. Therefore, I have something to say on how.
But then what do you say about this aspect alone? This is what we wanted to know.
Yes.
That election commissioner should also be given the same protection.
I'll try this one. What do you want to say?
Provided further. So that argument is based on provided further. We just wanted you to address that I think that should be the. We have to move on anyway. We never get to.
Yes, Lordship, let me just take your Lordships to few paragraphs in TN Sessions case, and then it's in volume 3.
So that, Balbir can take over now because. Yes.
You want.
Just one is, I think the lot of answers are there in 324 itself.
Authority is complete.
No.
Whichever way, it's between you both. I mean.
No, we had a good combination.
So, of course, I support whatever.
We have concluded, we want to know because we have to just.
I know. I'll just do. I also thought I will not read out all the judgments in extension.
Don't please.
We have prepared a note.
Just give us those paragraphs.
We have prepared a note where relevant paragraphs are.
That is it.
Very handy for your Lordship.
Please.
We have prepared it. I don't read out extensive paragraphs.
Don't do that.
We don't want to do that. So just only this paragraph from TN session, page 1522 of that volume 3.
Paragraph of that.
Paragraph 11, 1522. And then turning over to page 1523, within 1522 paragraph 11, just after placitum F, there's a sentence beginning. These have undergone a change after the ordinance which was so amended the act as to place them on par. However, the proviso to clause 4 of Article 324 says the CEC shall not be removed from his office except in like manner and in the like grounds the judge of the Supreme Court. And the conditions of service of CEC shall not be varied to his disadvantage after his appointment. These two limitations in the power of Parliament are intended to protect the independence of CEC from political and executive interference. In the case of ECs as well as RC, the second proviso to provide that they shall not be removed from office except on recommendation of CEC. It may also be noted that while under clause 4 appointments of the consultation election commission is necessary, there is no such requirement in the case of appointment of EC. The provision that ECs and RCs once appointed cannot be removed from office before the expiry tenure, except in the recommendation of CEC, ensures their independence. The scheme of Article 324 itself is that after insulating the CEC with the first proviso to clause 5, the ECs have been assured independence, the functioning of providing them cannot be removed except the recommendation of CEC. Of course, the recommendation of Supreme must base on intelligible and cogent consideration which should have relation to the efficiency of the election commission. It is because the privilege has been conferred on CEC to ensure the ECs and RCs are not to the mercy of political and executive bosses of the day. That is where the CEC's role comes into play, not because the CEC will act whimsically. And it's necessary to realize the check and the executive part to remove is built in the second proviso to clause 5 safeguard of not only this country but the election commission body. Therefore, the power to be exercised by the CEC as per his women caprice, the CEC himself would become an instrument of oppression and would destroy the independence of the ECs. And the RCs are required to function the threat of the CEC recommended removal. Therefore, that's a matter of experience. That's a matter where it is demonstrated there is something which has gone wrong in the state of Denmark. Then one more paragraph, paragraph 16 at page 1527.
Yeah. Can we note it then?
1527.
Paragraph 15, we.
Paragraph 16. While it is true that under the scheme of Article 324, the conditions of service and tenure of officers of all the functionaries for the election commission determined by the president unless determined by the rule law made by parliament. It's only in the case of CEC that the first provision to clause 5 lays down they cannot be varied to the disadvantage of CEC after the appointment. Such a protection is not extended to the ECs, but to remember that by virtue of the ordinance, CEC and ECs are placed in a part of the matter of salary and etc. That the absence of such a provision for ECs make the CEC superior to ECs. The second ground relates to removability. In the case of CEC, it can be removed from office in like ground as a judge of the Supreme Court, where the ECs can be removed on the recommended CEC. That, however, is not indicia for conferring a higher state of the CEC. The so hold is to overlook the scheme of Article 324 of the Constitution. Remember, CEC intended to be permanent incumbent, therefore, in order to preserve and safeguard independence, he had to be treated differently. That's because there can be election coming to the CEC. That is not the case for the EC. They are not intended to be permanent incumbents. Clause 2 of Article 2 suggests that a number of ECs can vary from time to time. In the very nature of things, therefore, they could not be conferred the type of irremovability that the third of the CEC. If that were to be done, the entire scheme of Article 324 would have to undergo a change.
That's right.
So, please, Judge. And this copy is for the court. You would like to read your plan? This is yes.
Yes.
Yours. So, but I hand over, I just hand over this. You hand over both this to the court, and then the High Court judge. First High Court judge, then this. I just want to place a judgment to the Andhra Pradesh High Court for a very small reason. It was in the context of that reorganization.
Paragraph.
Andhra Pradesh. And that, in the first page, the reliefs is are set out. The Honorable Court will please issue a writ or order reduction in the nature of mandamus, declaring that Article 3 of the Constitution of India is violating the basic structure and the preamble of the Constitution of India, apart from inconsistent with other provisions of the Constitution of India, particularly part of the Constitution of India, and quash and set aside the same or alternately declare the Constitutional Amendment 1955 insofar related to not ascertaining the views from the state legislature pertaining to provision proposed in draft bills in the state assembly.
What is the relevance? Why are you bringing?
No, I'm just kindly turn over to paragraphs 4 and 5 and 6. Now, two propositions. One, that there cannot be a suggestion that one part of the Constitution originally enacted is in conflict with the basic structure.
That we.
That's right. There cannot be any suggestion like
We don't have to. Leave.
Right.
Parent constitution, one cannot attack.
Even the basic structure.
Yes, but amendment act can be.
It's always a law.
Yes.
An Article 368 law, even
That
amending
we
the Constitution can amend the basic.
That we don't need any judgment.
So it only says that, I only want to say that in a recent context, the court has occasion to that. Because an argument that the note ultimately given by Mr. Prashant Bhushan says in the last paragraph, declare 324 that position appointment by president as unconstitutional. Therefore, if that is not to be done at all,
Obviously.
and there is going to be some other premise. Therefore, to suggest to go further and say I am saying unconstitutional because it offends the basic structure, that again is a flawed proposition.
Yes, that is the demand. Doesn't mean that every demand is to be accepted.
Absolutely.
No, that's not even my demand.
That's how his note ends. That's how the note ends.
All right.
We have prepared notes on cases. One, Militant will try to place before your lordships. And the other is just to give this first. So go into the book. There's one title called Note 3. This is the new note on paper. You can.
What is your... Yesterday, we did not, at least I did not.
The lordship is...
Article 326 of the Constitution.
Yes.
And the judgment of Justice K.M, the Haryana Panchayat case.
Yes.
Where lordship a constitutional right. Because if you see Article 326, it speaks about every person above 18 years. We conferred a constitutional right to vote. Article 326.
That's.
So whether it's whether the judgment in 2013 10 SEC page 1, that is in the PUCL matter.
Yes,
that's by 3 judges bench. That is not noticed.
Yes.
But since we are a 5 judges combination, we may have to go into the question whether right to vote under Article 326 actually partakes of a constitutional right.
That's.
What is your thing? What is your...
No, that's why I want to come back saying the 326, since it's talking about an adult suffrage issue, whether Parliament can enter into it and then add or decrease. If that's going to violate again, let's say the 18 or 21, many considerations can come up with that.
As it stands, every 18-year-old boy person not subject to any disqualification, which are mentioned therein.
That's true.
So
amendments were brought into the provision.
Correct. Subject to that, there is a constitutional right, isn't it?
That's true. The question then will be whether that amendment stands the test of a basic structure or any other fundamental right. That will be the only test again in all the circumstances.
So what's your argument as to whether it's a statutory right or a constitutional right? Because it actually partakes of 3 rights. One is it's a legal right under the statute, following the constitutional right under Article 326.
Right.
Thirdly, it also has features of fundamental right under 1920. There are 3 aspects to it.
I understand that. That's why the judgment referred to Lord yesterday on the stage beyond the right to vote.
That's right.
That's right. I see that.
So it's also a constitutional right. This is how it will have to, We have concluded, we'll move on to Balbir.
Yes. I just conclude.
I hope you will not hold up.
He's ready to spring on. And I don't want to take I know. So I just in these notes on judgments, and also we have a compilation of judgments. I just want to flag, worships. So there is a separate compilation of judgments which is given to the court, not this one. There's
Yeah, but are these beyond the ones already submitted? Because 3 volumes have been.
No, I think there's a compilation like this.
4 volumes. Yeah.
This is on behalf of the respondent. We'll just will make a note of the judgments I want to place reliance upon. Serial number 1.
What proposition are these?
Paragraph.
Broadly on the theme that, like you also know that a mandamus is not a right creating writ. It is only a right enforcing writ. It doesn't create rights. So on the question
of relief.
So when there is an antecedent legal right, you will have it enforced through a mandamus.
Yes.
You don't create a right by that.
Except that continuing mandamus.
That is when a mandamus is already available. If it's already available and can be invoked, then you have a continuing mandamus.
That all the 5 writs are relief.
For these judgments only go to show the limits to which a mandamus would go, and then circumstance when the court goes on to say constitution benches and 3 judges benches, which say that we will not certainly go beyond these lines. So all of those
habeas corpus may create a right.
Habeas corpus because of
not other 4 writs.
Liberty.
Yes.
That's why you ought to say what freedom does this freedom have. Therefore, liberty stands on a higher footing, absolutely beyond any consideration.
Mandamus doesn't create a right.
No dispute about it.
So I only want to show how, even despite the growth of a law, Nagappa said, we are leaving behind all those technicalities of English administrative law. But even thereafter, the question is, there will be some outer limit where you will not create a right and say, the court will create a right and have it enforced too. And then
We should not ignore the power available under 142. That is the final Brahmastra.
I just have only one word on that.
Because that is the basis for all this.
I'll have one word on that. I'll give an example and then I'll conclude. You'll also make a note of this, and the paragraphs are given here. And Ashwini Kumar and then Vivek Krishna and serial number 1, 2, 4, and 11 and 12. 1, 2, 4, 11 and 12 are important for purposes. And on 142, just one illustration, that I will conclude with that. We had a Vyapam scam in Madhya Pradesh, admissions to medical colleges. So people got into medical colleges by some illegal means and ineligible students. So by the time the matter came to the Supreme Court, many of them have completed 4 years, 4.5 years, some were in 3 years, some had gone to the residency stage. A 2-judges bench of your lordships went into the matter, and one honorable judge thought, why should a period of study undergone by a student should go a waste? It will be an economic waste for the student, also a national waste. So the learned judge thought that such students can be asked to serve for a period of 5 years in army, etc. And thereafter, on a completion of the tenure, they may have their medical registration done. The other learned judge disagreed with that. On the disagreement matter went before a bench of 3 honorable judges. And I was assisting the court in that matter for some of the petitioners. I said, a view taken by the learned judge regarding this waste issue is a very important, very subtle but an important, promotion of a value of education. But the 3 judges did not agree with us and turned down that request. And they said Article 142 perhaps cannot be invoked, and in these circumstances also. The point I want to make is the 2 important expressions used in 142 is in a cause or a matter. To do complete justice in a cause or a matter. A cause has a certain higher connotation, namely where the law does not really address a cause. In the initial days when 142 was being used, for instance, matrimonial disputes, compounding. Section 7B of the Hindu Marriage Act would not have provided for a compounding. Therefore, for 6 months you wait, 1 year you wait. It takes a long period before the trial court. Therefore, court try to deal with that matter. But over a period of time, you then try to land into certain other areas. So the cause of a matter is a very important guideline. And if there is a cause, means something which is not addressed by the law, and that not being addressed by the law is now presented to the court, and the court must resolve it. There is a cause of national concern, importance, so on and so forth. And if there is no such cause, and if Parliament or law has addressed it, but then we reach the second stage. It has been addressed, but inadequately addressed. Then comes the question of violation of rights, so on and so forth. That's how the continuum of entering into one. Otherwise, the reservoir, it is not a jurisdiction. It is a power and an authority like the inherent power in section 151, much more than that, because we are a constitution. So these are the broad areas where 142 is looked into. And I don't think I need to take the lordship longer. I hope wherever there is some shortcomings in my presentation, I hope I will be pardoned for that.
Thank you. Thank you.
Thank you very much.
As Mr. Balbir Singh is just taking over, AG started by referring to Justice Frankfurter, spaghetti spine.
Please, Manoj.
So I was just wondering whether Justice Frankfurter was introduced to spaghetti on the dining table or in the kitchen larder. If it is in the kitchen larder, spaghetti would be very stiff. Nothing would be malleable there. I'm just wondering.
Thereafter, it has been referred to in larder.
No.
Well, if I try and draw analogy on that, is the cooking more important or cleaning more important? So you will start cleaning first and then cooking, or in today's context, should we have a cleaning first before we start cooking so far as 324 is concerned? Sorry.
Just one small final. As I said yesterday, if the court were to reach the first stage, a gap or a vacuum affecting fundamental rights, then Parliament will address into that, all that. Unless the court reaches stage, the question of whether there is any interim measure, etc., will also not arise. That may not arise, because that will introduce needs and uncertainties in a system where it is working fairly well. I just only want that.
Well, that if my lords permit to start with where.
No, actually, you are appearing for whom?
Well, I'm appearing for the Union of India only.
You're for the Union of India.
Yes, well, just to carry on for limited purpose of 142, for doing complete justice, that's the fundamental underlying factor of 142. So there should be apparent, visible injustice happening by delivery of something by the court.
Come here.
So if there is, to make complete justice or to do complete justice is where, in my respectful submission, 142 is what steps in. So therefore, there has to be an underlying foundation to see that if there is any injustice happening, that's what I'm only adding for limited purpose, Malas, where the cause and matter we look at. So that injustice is extremely important, Malas. But I'll just pass on so that I remain in a discipline. I'll just pass a small note so that what are the points I'm taking forward. But what seems to be bothering my lords is that 34.2, the appointment is a point of concern. That seems to be the concern which is arising to this court. And based on that, my lords are linking it to say that the fairness and independence of functioning of a body. And my request would be, when we read 324, kindly see commission and commissioners separately for a minute. We are looking at independence of an institution. So we are looking for independence of the institution, and we are looking to appointment of commissioners for that matter, that may be CEC or EC minutes. If the mechanism provides that the institution can function independently, and so far as the appointment of the constituents of that institutions are concerned, that if the constitution makers thought it fit, after deliberating what can be the pitfalls, or if I may call headache, that to what extent and till what time it should be left as it is, unchanged, unamended, and with the wisdom of Parliament, whenever they think it is right, should be done by the Parliament. And it is not that the Constituent Assembly was not conscious of the fact, and as my Lord said, that they were aware the headache is going to come, and the headache is here today. So we are dealing with that headache today, Malas. Knowing fully well that there is going to be a headache 75 years down the line, that there were 2 or 3 options which were discussed or debated at that point in time, not chosen, not opted for, and the route of the leaving to law to be made by Parliament is to be left. And Malas, in the beginning, my lords asked a question: what is the meaning of the law to be framed by the Constitution? And if we see, the language is very interesting. 324.2, my lords need not specifically open, I'll say, subject to the provisions of any law made in that behalf. So some behalf, some law can be made by the Parliament. That's what the 2 says, sub-article 2 says. Now, at that point of time, either it was that it could have been plugged, and the one way of plugging was that the appointment should be with the 2/3 members of both the joint houses. That was the one option which was not taken. Second was instrument of instruction could have been there, that these are the instrument of instruction should be followed, and therefore this will safeguard the so-called attack on the independence of the institution, that also was not chosen in spite of the fact, noting that we are not absolutely adopting the American Constitution and we are adopting Indian with the modified, maybe instruments may be adopted or instructions may be adopted. That also was not to be done. Why in that case it is said that it is left to the Parliament, and why, unlike in 16(4)(a), where the option given, and if we see that mandamus can't be issued because that option is given to the state, if they think that the reservation is to be issued, that's a prerogative of the state. So that's a one way of 16(4)(a) kind of situation, enables the state to do it. That's a one way. If you look at 21(a) for that matter, shall make law. So that is another way that shall make law, which is there. This is a third way to look at it, subject to the law made in that behalf, which has been said. Well, in my respectful submission, and if we try and compare the constitution where these kind of phrases have been used, and are knowing very well there is a headache which is likely to come. In spite of that, in my respectful submission, and also coupled with the fact that at that stage, it was not seen as a multiple member body. It was seen only a one person, because nobody anticipated that we'll be in election mode 24/7 at some stage maybe. And therefore, we need a larger institution for that purpose. So therefore, and one more aspect was in the beginning, it was pointed out that democracy, the basic principle in the organs is a faith. And that's a presumption which is coming from MS Gill and so on and so forth thereafter. That there is a faith in the organs that everybody is going to fulfill their respective roles. That was the very fundamental and the basis of the constitution which was framed. And that's why in my respectful submission, when it was left in this form by the president, the faith was that ultimately, because we are dealing with the parliamentary decision-making process in a democracy, the will of people should prevail. And there is a faith that the system is going to function fine. Therefore, if that headache lands at some point in time, the first preference should be given to a parliament to make a law on that part, that do we need to deal with the headache in a particular manner. And besides the fact that yesterday my lords pointed out that in last 8 years, 7 election commissioner has come, or 8 years, or 7 years, 8 election commissioner has come. The data which we have seen, today, when we see, since I was also not aware, there appears to be in Wikipedia either the dates of EC position has been taken or CEC position has been taken. A cumulative is not given. If we look at a cumulative number, that seems to be on a higher side than the average, which was looking that it is being changed so many times. Other than the fact, two factors which I believe is bothering my lords while looking at 324(2) is that there are multiple reports which exist, and even Election Commission itself has said, the political parties themselves have said that there is a need to reform this process, and therefore one of the possible reform can be that we come up with the appointment fairer and independent than what is being today left to the executives in the current form. Well, this has already been argued that there is no underlying fact. We are not dealing with the position saying that a man of zero integrity has been appointed as EC or the CEC. That is not a question which has come. The best cases my lords have seen started from Dhanova is that whether the ECs are in line with the CEC and CEC agreeing with them or not, notification issues, withdrawn, post, abolished, all those factors. So that is more to do with the internal functioning of the institution, which is not under challenge. Today, everybody agrees on this aspect that institution has worked perfectly fine. The most important part in democratic process is timely election of the election to be conducted. That's the first fundamental part. Second is the participation of people who are willing to participate. On both counts, there is not even a single allegation that by virtue of election not being conducted on time, the existing ruling party is going beyond the period of 5 years and therefore they're still retaining a power. That kind of anarchy is not being pointed out. Second is, it's also not a case, somebody saying that we had 297 million of the eligible voters in the last election, 67% voted, but 5% were not allowed to be voted. So therefore, it is not case there is a democratic process in participating in the forming the parliament has not been carried out. On both the factors, there is no allegation on this aspect. And why I am pointing this out is, with all humility, that 3-4 cases which we have seen where the court have intervened and laid down certain kind of a guidelines, or I would call guidance, because it is for the time being, the law is not being framed. All those 3 cases are where the union was ad idem, and it was more in line with Article 21 kind of position also, which is much higher in terms of liberty and life. That, and there was some trigger point always. Even if we go for the judgment in Vishaka, the rape in Rajasthan was the start point where this debate started. And then the further debate happened, the international conventions were there. So therefore, there was a background material knowledge.
Not adversarial, actually.
That not adversarial knowledge. And today, if I may not be right to say that it is absolutely zero adversarial position knowledge. Today, there is a process which is functioning. And what is there in my Lord's mind, looking at, appears to be that seems to be some anomaly in 324 so far as the independence is concerned. What we do in that case? Well, I asked myself a question saying that by virtue of providing an alternate arrangement, with whatever that arrangement would be, a composition of CJI, Prime Minister, Leader of Opposition, are we going to dislodge President from 324.1 and 324.2? In my respectful submission, the President cannot be dislodged. If the President cannot be dislodged, are we going to dislodge the aid and advice of the Parliament or the Council of Ministers? Are we going to dislodge that? If we are not going to dislodge that, then what do we gain? Are we trying to create a recommendatory body which is going to recommend to Prime Minister, to the President, and President ultimately has got the aid and advice available? Then we are back to square one. Or we are saying that we dislodge President and this body is going to function, and this body is going to get into the appointments of the CEC and EC for that matter. And I presume my lords are certainly not looking at lawmaking. I've understood, so therefore I'm not laboring on that. That there is no intent to dislodge the President out of the current situation, and not the aid and advice as well. So where are we heading to when we look at what the solution? So that's the one thing which I wanted to park before my lords, to see that what are we trying to achieve. In the underlying fact, there is no real basis to say that 2 very important factors of the parliamentary democracy, which is to be performed by the Election Commission, has not been carried out. There's no allegation of that nature. So looking at it from that point of view, my lords, bear this in mind, my lords. Where do we draw a parallel of this nature, my lords? And the reliance was on NJEC case. And there was interestingly a discussion on the role and functioning of Election Commission there also. There was a discussion on the role of committee reports also, which were in the favor of NJEC, and my lords looked into that part. There was also an examination of parliamentary debate, that how parliamentary debates are to be looked into. And after that, looking at everything, Justice Madan Lokur in one para finally said that the appointment of judges and Election Commission is completely different. So you can't equate, and the reason seems to be not far in my mind. This process is amenable to judicial review. A decision by this court or the process of appointment of judges is not amenable to a judicial review. That's a very, very important fundamental factor. Before I move forward, 3-4 paras I want to read, and those are going to be clincher in my respectful submission, because that has been considered in NJEC. This is 2016, I pass on the book.
Yes, get that there. 2016.
I'll just give the 2016 5 SEC, page 1. If my lords can kindly come to page 242, para 27. There are a few paras are going to be very relevant.
Page 242, para
27.
27.
27. May I please?
Yes.
The learned Attorney General also referred to Article 145, whereunder it was open to Parliament to enact law framed by Parliament for regulating generally the practice and procedure of the Supreme Court. In the absence of any such law, Supreme Court had liberty to make rules for regulating the practice and procedure of the court with the approval of the President. It was submitted that even on elementary issues like procedure, Parliament and or President were assigned a role of the Constitution and activities strictly in the judicial domain, even to the extent of that policy. Now, kindly, role of Election Commission, there is a one para 44 on page 253. On page 253, para 44. In the like manner, our attention was drawn to part 15 of the Constitution pertaining to elections. It was submitted that Article 324 vested the superintendent direction and control of elections to Parliament and the legislature of every state, and election of the office of President, Vice President with the Election Commission. The Election Commission, in terms of Article 324(2), was comprised of the Chief Election Commissioner and such number of other election commissioners as the President may from time to time fix. It was submitted that the appointment of the Chief Election Commissioner and the other election commissioner was to be made by the President and was subject to the provisional law made by the Parliament. It was further pointed out that under Article 324(5), the condition of service and the tenure of the office of the Election Commissioner and the regional commissioners is regulated in the manner as the President may by rules determine. Of course, subject to the enactment of law by Parliament, so as to depict similarity with the matter under consideration, it was contended that the proviso under Article 324(5) was explicit to the effect that the Chief Election Commissioner could not be removed from his office except in like manner and on like ground as a judge of the Supreme Court, and in furthermore, that the condition of service of Chief Election Commissioner could not be varied to his disadvantage after his appointment. It was contended that the Indian experience had been that the Chief Election Commissioner and the other election commissioner had functioned with absolute independence and that their functioning remains unaffected despite the fact that their appointment has been made by the executive. It was submitted that the impartiality and independence emerged from the protection of the condition of services of the incumbent after his appointment and not by the method or manner of his appointment. That was the argument which was raised. And the appointment of judges. This was a parallel which was shown. Now, kindly see, the para 45 also may be relevant to some extent. I'll not read the case on Bharati, but 45 sees it was also the contention of the learned Attorney General that implicit in the scheme of the Constitution was a system of checks and balances, wherein the different constitutional functionaries participate in various processes of selection, appointment, etc., so as to ensure the constitutional functionary did not exceed the function and responsibility assigned to them. I'm purely reading on limited purpose, checks and balances. If there are existing checks and balances. Let's now kindly come to page 4, para 456, which is available at page 490. 490. And interestingly, in this case also, while debating on the appointment of judges, instrument of instruction was discussed. Page 456, page 490, para 456.
Yeah.
After a few months, on 11/10/49, the President of the Constituent Assembly was informed by Mr. T.T. Krishnamachari that Schedule 3A is not being moved and that it could not be taken out of the list. He also moved for the deletion of the Schedule 4 from the draft Constitution, explaining the move to delete Schedule 4 from the draft Constitution. It was stated that the matter should be left entirely to the convention rather than to put in a body of the Constitution as a schedule in the shape of instrument of instruction, and that there is a fairly large volume of opinion which in favor. In that case also, it was specifically pointed out that there can be instrument, but that was not provided, except that what we see in 124 today. And this portion is reproduced, which starts with the debate on the instrument of instruction, which has been done in this case also, not followed those in today's time also. Then, my lords, actually come to para 579. I'm just showing page 539, and para 579. 539. Extensive reports were there. I'm just pointing out one or two.
539.
Page 539, para 579.
Yeah.
Be that as it may, NCRWC submitted its report to the Prime Minister on 31/3/2002. In Chapter 7 of the report relating to the judiciary, NCRWC recommended in para 7.3.7, therefore, establishment of a NJAC. It was observed that such a commission was necessary for the effective participation of both executive and the judicial wings of the state, as is the integrated scheme of the machinery for appointment of judges. I'm not reading other reports on this, so I'm just pointing out there were multiple reports which were suggesting that there should be a participation of the executives on this part. Now, let's kindly come to para 647, which is available at page 567. Para 647,
At page
567.
567.
Yes, 567 and para is 647.
Okay.
This is regarding the assembly debates. What's the role of the assembly debates?
That's right.
It is quite clear that the overwhelming view of the various learned judges in different decisions rendered by this court and in other jurisdictions as well is that, point 1, a reference may be made to the CAD or the parliamentary debates, which is referred as a relevant material, to understand the context in which the constitutional or statutory provisions were framed and to gather the intent of the lawmakers, but only if there is ambiguity or uncertainty or incongruity or obscurity in the language of provision. A reference to CAD or the parliamentary debates ought not to be made only because they are there. 6.447.2. CAD or parliamentary debates ought not to be relied upon to interpret the provision of the constitution or the statute if there is no ambiguity in the language used. These provisions ought to be interpreted independently, or at least if reference is made to CAD or parliamentary debates, the court should not be unduly influenced by the speeches made. Confirmation of the interpretation may be sought from the CAD or parliamentary debate, not for vice versa. So, today when we look at the debate which were there, knowing fully well there is a headache. So therefore, one option was that headache could have been taken care to straight away say that you shall make law. End of the matter, Parliament would have made law and we all would have been grappling with that law instead of dealing with the constitution per se. Now, as we kindly see, now, para 772 now. And this is by Justice Lokur, 772. On page 613, I'm sorry.
Yes.
Similarly, that's how it starts.
Yes.
Page 613. Similarly, the appointment of chief election commissioners and the election commissioner under Article 324 of the Constitution does not require the president to consult anybody, even though free and fair elections are undoubtedly vital to our democracy. Since the consultation provisions were incorporated only for the appointment of judges, surely the Constituent Assembly had good reason for making this distinction. Justice K.M has referred to other presidential appointments in his draft judgment, and it is not necessary to repeat them. What is important is the message sought to be conveyed by the Constituent Assembly and the sanctity given to a recommendation by the Chief Justice of India for the appointment of judges of the Supreme Court. Well, when we look at the theme which has gone so far as looking at the approach toward the independence of judiciary vis-a-vis
the obiter.
Well, I completely. I'm borrowing for the persuasion.
On a light-hearted note.
Yes, Manoj.
Justice Lokur, after his retirement,
I am conscious of that, and that's what the start.
headed a committee and which has given a report where there is an article written about the abuses in the matter of appointment. We hope you are aware of that.
Well, I'm aware, and that was the start point, which was raised in the beginning itself, saying that Justice Madan Lokur has raised this one. All I'm saying is, Malas, that when we have a comparative provisions, and this is only for the purpose of persuading my lords, that it is not that the differentiation of the two processes so far as the independence of judiciary was not examined. It was examined, but certainly that was no core point for examination which was there. The role of assembly debates were considered, role of the committees were considered, and contrary to those role and report of the committee, the language of the 124 was relied upon to say the consultation, what is the meaning of a consultation, where the Chief Justice has got the power, the entire power left with him by virtue of that, and therefore that's there. Now, in light of this, let's kindly come to 324 for a minute. Article 324. And I'm pointing out that we are segregating the independence of the commission versus the appointment of individuals.
Was not Article 142 also involved in the judge's case? Was not 142 drawn upon by the court, by this court?
Yes.
Because it's put in place a lot of direction, including the third case.
Yes.
Various procedures which completely an elaboration which is not justified with the text of the constitution.
Please, Manoj.
Entirely a contribution by the court.
Yes, in all three judges over a
Peculiar
period of time.
conditions as they found it in this court.
Yes,
To
Manoj.
make provision for appointment of judges.
Yes, Manoj.
So is that not a case where, like the earlier case law, if you really go back to the first case of adoption
Yes, Manoj.
by this is Bhagwati,
Yes,
by foreigners, that is how it started.
that's how it started. Yes, Manoj.
It's all referred to in the CBI case.
Yes.
Union Carbide, the Chief Judicial
Magistrate case. Yes.
from Ahmedabad. All of the cases which perhaps it may not fit in with our situation.
Yes.
But the judge's case appears to be a guiding factor from which we can draw inspiration, and perhaps if we are otherwise inclined to take it forward,
Please, Manoj.
apply it in the facts of the case. Otherwise, you are right. Because other all cases where there was no material.
May
Well, the
I add that it's surprising, but the Supreme Court invoked Article 142 only on about 9 instances till 1996. 9 instances.
And thereafter,
After that, it's opened the floodgates.
Well, the
Because of all these 13B.
Yes, because of these.
Well, coming to try to answer that how do we differentiate this position which has been taken also? In 124, there is clearly a consultation which has gone to the interpretation also. All I'm saying is that in 324, do we need to go down to that level to see that 324(2), when the institutional functioning is not in dispute, appointment of one man may be very relevant man and equivalent to an institution in certain situation, may not be today because we have multiple body which is there, is brought down to a level to say that because your appointment mechanism of a particular individual is, let's say, opaque and it is not visible, your institution may be functioning fine, your elections are conducted on time, there's a representation of people which is required for forming the government. Should we get into that part or not? And that's my endeavor, is that first point which I'm pointing out, is there is a gap, is there is a vacuum. We are looking at it's not a case an individual has come to the court or an individual appointment is under challenge. Hey, the functioning of the institution is under challenge. And functioning of the institution in 344(2) is one of the aspects of appointment is election commission. That can be, my lords, I've seen that they try to stitch with 19(1)(a) and therefore a person going to vote. And so I can understand that part. But should it be taken to this extent to say that a one person who's the part of the institution which is functioning fine, his appointment we need to set to the core? When the parliament in last 75 years thought it not, I'll not say fit, but not maybe desirable. So the desirability test or utopian approach to say we want to set a perfect system should, in my respectful submission, this court should go to that extent to say that we want to set up that partners. But if we go further down, there is a guidance in this. We look at 322(4) for a minute. It says before each journal election of the house, each journal. So there is some decision making before each, and that's why today it may be by virtue of the nature of activity which the election has shaped into, it has changed. But the constitution still recognizes that each election is a separate feature. You may be needing one election commission EC, or you may be needing 5. So equating it with the CEC to say, should in absence, in the presence of 324(2), should it be taken to that level? And in my respectful submission, this was the background in TN session, where in spite that there is an amendment later on made in 1990 Act, still the court chose to say that removability cannot be equated to the extent with the Chief Election Commissioner. That's what the para very clearly says, that irremovability is given equivalent to the judge of this honorable court only to one person. And the reason for that seems to be is Today, we are contemplating that we have understood the entire election process in the country. We don't know what the 100 years down the going to be, Malaz. And this is a living document. We have to live it with it. These multiple courts are going to be interpreted. On the face of it, 324(4) gives a suggestion that before each general election to the House of the People or to the Legislative Assembly of each state, and before the first general election and thereafter, before each biennial election of the Legislative Council of each state having such council, the President may also appoint after consultation with CECs. This liberty is taken away the moment somebody is fixated for 6 years period. Somebody can make a claim, he can be removed, which has happened to notification which has been taken away saying they will remove the post.
Exactly what we were about to ask you.
Yes, sir.
Can you tomorrow undo the notifications of 93?
Yes, sir.
By which 2 posts of election commissioners were created, against which one was Mr. Gill was appointed and another was
yes, sir.
Can you today do that in law? In law, can you do that? You can remove, you can say, we don't need the election commissioners anyway, you go back to the old system.
Please, Malas.
Of having one chief election
Please,
commissioner.
Malas.
You can do that in law.
In law, yes, Malas. And that has come, and I'm so grateful. That's where the judicial review comes in. My lords examined this position.
And did not accept it in the case of Dhanua.
Yes. And
see, in the case of Dhanua,
yes,
Dhanua came with the same complaint.
Yes, Dhanua came
the
with
man
the same.
was working as chief secretary or
Of a state, and my period has gone.
Service commission, and he came to this court complaining, I was here for less than 3 months.
Yes.
And because of, the chief election commissioner, Perishastri.
Yes, Malas.
He had a problem with him, respond number 2.
Yes, Malas.
And then they were removed.
They were, yes.
The court went into it and the court said that actually you are the problem. The election commissioners were the problem because they were having a constant rift with the chief election commissioner and throw their petition.
Well, it's like a cricket team.
So subsequently, when Sheshan took over in December 1990,
yes,
the midst of his term, you bring in this two
more.
So thereafter, this has come to stay.
Yes, Malas.
Now we have election commissioners, it's a multi-member team.
Member body.
But even that can be undone by you in law because it's not part of the constitution.
Yes, it's correct. The president can issue a notification.
Isn't removing the posts?
Yes.
You can remove the posts.
Well, that's where the difference between the appointment of judges and appointment of election commissioners, because that can be tested, and as a matter of fact has been tested. Finally, whatever. Well, my lord said it's a man of character ultimately we are looking for. The appointment process can take a person to a position of CEC or EC. How their interplay role between the parties, that the appointment process is not good to. We get the best batsmen in the team. 2 best batsmen fighting each other because somebody wants to open the inning and somebody wants to get to the second down. They'll fight because they're equally powerful in the team structure. So therefore, they'll always fight. That's a test of a human aspect, that who has got what kind of a qualities in that. But that has nothing to do so far as the appointment process is concerned. Appointment process, we were briefed, Malaj, and we were discussing with the Learned Attorney General also, whether the existing structure, the manner in which the elections commission, the elections are being conducted by this body, how much role of manipulation is there? How much role? And that's the reason why this has not happened, Malaj. We can see government after government, which has been coming and going. And in fact, after these, the electronic voting machines which have come, it would have been the easiest way to manipulate. If somebody would, zero complaint, nobody, not even the opposition parties, losers have ever complained, barring certain instances which have been there. But the system, I've been told, the system is of such magnitude that it doesn't allow somebody to be partisan to an extent to say that it's going to change the formation or going to affect the electoral voting to be compromised in some sense. The whole mechanism doesn't permit that somebody can go rogue. The system, and that's why we are talking of a independence of the institution, and we are not talking independence of the individual. The individual appointment.
Supposing the election commissioner is asked to take on none less than the Prime Minister himself.
Please.
Giving an example.
Yes.
Just an example.
We are testing this one.
Hypothetical example. Supposing the election commissioner sort of, is so weak-kneed.
Yes.
That he says, okay, I carries with it, he doesn't get around to doing it. Will it not be a case of complete breakdown of the system then? It's just giving an example.
Yes, Valasi.
The reason being that he is a man who's supposed to be completely insulated.
Yes.
And when you talked about character,
Yes.
character consists of various components.
Various components.
Like integrity,
Yes.
honesty. But one particular characteristic required is independence.
Well, certainly, yes.
Independence is, like you said, we don't care. One of your election commissioners, in fact, resigned.
Yes.
You don't want to go there.
Yes, Police.
So these are the aspects which perhaps the participation of a larger body,
yes,
instead of the cabinet, which always, as we know, it's only self-serving because it's natural.
Yes.
They would like to perpetuate themselves in power. Any party.
Please
I'm
don't.
not saying all parties will have that.
Yes, all parties, irrespective.
Irrespective of the political color.
Yes.
That is why from 1990, committee after committee after committee keeps reporting. There is a dire need for change. Political parties, leaders keep shouting from the rooftops. But on the ground, nothing will happen.
Well, interestingly, I'll come to the committee part also because there is some examination. I've seen these committee reports closely. Simple example I'll give. My Lords asked a question in the morning saying that why you are still voting the expenditure and not charging it to Consolidated Fund of India. The report we read clearly say no need. There's in the same page, on the same page we were reading, the last para on that say no, this is fine. It's expenditure through voting is fine. One report saying this. So in parliamentary democratic process where the functioning of administration has been given to our various ministries, it is extremely important that these are to be evolved with the period of time. These are to be reformed or improved over a period of time. How do we do it? We acquire more knowledge, we acquire more minds to apply to it, and that's how we create these committees. When we look at a law commission, there are the functioning, and why do we go far? This court has got a, if I say, foolproof system so far as the appointment of judges are concerned. But there are stray instances where things go wrong, which come to the knowledge. The whole idea is, should we change this to an extent to find that there are stray instances which are happening? And I'm not saying this can't happen. This can happen. And second, the best of the appointment, whether that is going to set right the system inter, say, the participant or constituents of a body like this court also. Doesn't guarantee that. But all we are trying to do is to safeguard the position. And my endeavor is, when I'm particularly pointing this out as well, the appointment of a member of this commission, how important is to be considered to say that we're going to dislodge a president. If we are not dislodging, then we are going to the same position to be done. And in my respectful submission, 324 is a vacuum of the extent. How much we should look into our transparency. Is there an extent we measure? Is we measure the extent of our independence we are looking at? Well, even if somebody by any route has been appointed and government is going to be one of the participators in that whole functioning, is it going to completely eradicate so far the relationship is concerned?
You will find one thing. The test denominator has changed from time to time.
Certainly.
We learn by experience.
I'm grateful, yes.
Let us talk about the judiciary in the first instance.
Yes.
There was a time when the selections were made at the literal level, just on the request being made by the Chief Justice of the state to a lawyer, please join.
Please,
and on his request, the appointments were made, no selection process.
Please,
that also worked very well.
One of, yes.
And we find the finest of the persons who have done, and they came to this court. One system.
Yes, certainly.
But the very system, at a later point of time, started a question mark.
Yes.
Then we thought, no,
yes,
this system will not work. Let us introduce a new mechanism, which is fair, open, and available for the public also to know what kind of a mechanism is on place.
Yes.
We changed it.
Yes.
So that system introduced.
Yes.
Now we find that system is also not working.
Possibly, yes.
Question is, so what we change ourselves? Same is the question here also.
Yes.
If you go in service jurisprudence,
yes,
there was a time when the appointments were made purely on interview.
Yes,
purely on interviews.
Yes.
And never questioned.
Yes.
But later the time came that this court also intervened and the judicial verdicts came forward that no, curtail the interview.
Yes.
The decision came because the experience shows that whenever the discretion is being vested with authorities,
yes,
it is by and large not being used for the purpose.
Yes.
It being. We change the
system.
Said no,
yes,
curtail the interview criteria and bring it to 15%, 12%, yes, whatever according to the
yes,
need and requirement. 100% interview is gone, almost gone.
Yes.
So we learn by experience.
Yes.
Same thing we put to them also.
Yes.
if the very mechanism being followed for last 70 years, it's 69 years, whatever you call it,
Yes.
where was the occasion for the petitions to be filed and calling upon the court to intervene?
Yes.
They were also silent. Ground realities are different.
Well, yes.
What we think is, and what we tell you one thing,
Please, Maharaj.
we only want one thing, subject to what you say.
Please, Maharaj.
We are not saying the system is not correct.
Please, Maharaj.
We are not saying that the attorney said there is no trigger point.
Please, Maharaj.
We don't want that the trigger point should come, then only this court should move.
Certainly, Maharaj.
What we think is, we want is,
Yes.
there should be a transparent mechanism
Yes.
which to avoid all kind of reasons and complaints.
Please, Maharaj.
And people should know for whom we are going to work
Please, Maharaj.
in upholding the democracy which we are.
Please, Maharaj.
What kind of a mechanism you can put in place?
Please, Maharaj.
People are not going to question mark.
Please, Maharaj.
You say, no, we have a council of ministers, they advise the president, appointments are made.
Please, Maharaj.
Everything goes inside.
Please, Maharaj.
Now, we put to you also the same proposition. Show us what mechanism you adopted
Please, Maharaj.
in making the appointment day before 2 days before.
Please, Maharaj.
What is your mechanism of appointment?
What is the...
If somebody asks to ask, you say it's all right. Somebody can question it, will come forward.
Please, Maharaj.
Why should we grant you that liberty? Why can't we take a call? Yesterday we put to you. Have you brought any mechanism? Have you brought any mechanism in place in reference to which the appointment 2 days before have been made? Show us.
Right.
Or the same council of ministers and the president and goes on.
Maharaj, I'll answer, but the attorney and...
No, you are here.
Maharaj, I'll certainly, but since the instructors were there on this specific aspect...
Apart from instruction, are we saying that there is an underlying unease about the accountability of the Council of Ministers and the cabinet?
We are not.
Yes, that's what
We are not. Sorry, you don't understand this. We are not.
I just
We
want...
just want to know from you.
Yes.
We just want to know from our satisfaction.
Yes.
Let us know the mechanism you adopted.
I've told you, it's on the basis of a certain convention. There is a panel prepared, there's a DO to prepare. I've said so in my notes. Therefore, there is a procedure which is being followed.
Mr.
Right.
Attorney,
There is
ask you,
one more aspect I want to make.
Mr. Attorney, when the matter was taken up, Mr. Prashant made a mention.
Accusations can come from anywhere.
We are not saying accusation. Don't take it up.
Are we following?
Yesterday we put this question to you.
Established procedure, or is there a departure?
Attorney, we put a question to you.
Yes.
And our request. For our satisfaction,
Your Lordship.
show us the mechanism you adopted in making appointment 2 days before.
Your Lordship, the note which I've given, which in the saying,
Let us.
that how on the basis of seniority, on the basis of a panel,
Election
and the basis
commissioner
of,
is not on seniority. Chief election commissioner according to his own seniority.
not only even election commissioners are appointments on the basis of their seniority in the civil service. That's how I showed that. You
Our information is that the
Please
gentleman who has been
you
appointed
can flag off anything you
on
want. Don't do that.
Saturday, he took VRS the previous day on
That-
Friday in order to be appointed election commissioner on Saturday. This is how.
The office was vacant till since May. You're forgetting that. Since May.
Show us your notes that election
No,
commission is also appointed
in this note itself, I've said this is the order of their seniority,
Yes,
shows
you-
how they are appointed. So it is not a pick and choose at all. It's all every successive election commission is the basis of their seniority.
No, as we
The civil
understood,
service.
as we understood.
Yeah,
from
this also, and in my note.
As we understood,
Yeah.
let me be clarified. We understood that the chief election commissioner is appointed amongst the election commissioner who is senior. This is
Even
what you said.
the election commissioner, your Lordship, the date of birth indicates that, for instance, Mr. Krishnamurthy, his date of birth is 1940.
Your request is, are you aware how much is the civil servant according to your seniority working in the ministry of central ministry? That seniority can't work.
Whether that would be a matter for concern or an aberration, I don't know whether that would be, because then there will be no system can work. So there has to be some system where certain premises, certain fundamentals are said to be important.
No, that you understood that CEC is appointed on the seniority of the election commissioner. You are right. We agree with you.
Yeah.
Subject to something comes otherwise.
Yes.
We're talking about the entry level as EC.
I am talking about the entry level also. This gives you an indication. The entry level is also on the basis of a senior.
So we can take seniority of whom? Seniority civil servant.
In the civil servant, there is a certain element of seniority. They prepare.
From where you get the guidance that only civil servants are the only persons to be considered in the role of
The parliament does not say beyond civil servants, you have a system or a selection, a panel or a pool.
Why you are confined to civil
That's
service?
what, that's what we're entering into an entirely different debate. Whom should you pick up is the question. Are we entering into the debate? If there is a convention which picks up from civil servants because of their experience involved in administration and all that, then we must depart from the system. We will have a national pool of talents that will be available. Let us pick up in the national pool of talents. That is a complete departure from the convention. Unless, therefore, I said, if the convention is found to be wrong, then you're looking at where all we can pick up people will be eligible to hold the independent office. That's a very larger debate. Very larger debate. And I want to bring up 74, section, Article 74 for a minute, Lord's kind consideration. There's an inbuilt I think, protection available there. Article 74 reads like this: there shall be a council of ministers with a prime minister at the head of to aid and advise the president, who shall in the exercise of his functions act in accordance with such advice. Proviso. Provided that the president may require the council of ministers reconsider such advice, and either generally or otherwise, and the president shall act in accordance with the advice tendered after this reconsideration. Therefore, the president has that discretion. So, in a case where the president's doubt is triggered, the president will act. Therefore, there is an inbuilt guarantee that any departure by the cabinet or the council of ministers will certainly be addressed by the president. If you want to doubt the president, of course, that's a different question.
Yeah.
Therefore, there is an inbuilt guarantee available there.
I would also on that one address within my this question I'll address.
Yeah. Yes, Balbir, please.
Well, just straight trying to answer this question, that is the being convention. Interestingly, in case of a CAG appointment, which went initially to Delhi High Court, and this came to this honorable court later, and my lords agreed with the Delhi High Court. This was the question which was there, that what do you do? What kind of a convention it is there? And I just want to point out that because that's to throw some light that what is the nature of convention which is carried out in these kind of cases. This is Gopalaswamy and others. This is 2014. I'll show later this because some debate on the manner. Let's can kindly come to page 26, para 41. Please. Yeah, page 26, para 41.
So page ratio.
Yeah, please.
Yeah.
Please. The other decision referred to by the learned counsel for the petitioner, being Royappa's case and the decision in Manaklal and Ranjit Thakur Supra, are unexceptionable. In Royappa's case, the Supreme Court observed that the equality is a dynamic concept with many aspects and dimension, and it cannot be cribbed, cabined, or confined with the tradition and doctrinal limits. It was observed from the positivistic point of view, equality is antithetic to arbitrariness. It was further observed that in fact, equality and arbitrariness are sworn enemies. One belongs to the rule of law in a republic, while other to the whim and caprice of the absolute monarch. Where an act is arbitrary, it is implicit in it. It is unequal both according to political logic and the constitutional law, and is therefore violative of Article 14. There is no denying that there should be no arbitrariness in any state action, including the appointment of the CAG. The quarrel is not with this principle. The question is whether in the facts of the present case, there has been any arbitrariness in the appointment of respondent as the CAG. In our view, there has not. The respondent number 2 was appointed following a time-tested convention. As in the appointment of all previous CAGs in the past, so too in the present case, the CAG has been selected from amongst the civil servants who have rich and varied experience in the public administration. The procedure that has been established has worked itself into the convention over the last several decades is that the cabinet secretariat, which is headed by the cabinet secretary, who is the senior most civil servant, having knowledge about the competence and integrity of the civil servants of the government, sends the list of the shortlisted names approved by the finance minister to the Prime Minister for his consideration. The Prime Minister thereafter considers the said shortlisted name and recommends one out of the list to the President of India. for his approval. After the name is approved by the president, the CAG is appointed under the warrant and seal of the President of India. This is the manner in which the appointment to the position of CAG has been made in the past, and this is the manner in which the respondent number 2 has appointed as the CAG. There has been no arbitrariness in this process. It is not as if the shortlisted, if the shortlist was not prepared by the cabinet secretary, it is not as if the finance minister did not approve the same. It is not as if the finance minister has not recommended the name to the respondent number 2 or to the president. And it is not as the president has not approved the name of the respondent number 2. Therefore, the process of appointment which was followed as a convention has been followed, and there is no deviation from the same. Therefore, it cannot be said there was arbitrariness involved in the appointment of the respondent number 2 and so on. Well, if we look at this method, which is a called convention, which is there, and what is the in any public administration system to say that because Prime Minister is sitting with the president in terms of the conduct of business rules, and virtually somebody is be picked up without analyzing that what is the background of the person, how much experience he has got, how much period he has worked, which areas he's worked. There is certainly some kind of an application of mind in absence of any evidence which can come in a judicial review before this court, to presume that there is nothing which works except that the cherry picking which goes on. In my respectful submission, these are a convention which has worked for a very, very long time. Today, the assumption to be raised at a point saying that I will not believe you that the process is independent because you are unable to show me each file how it is being done. Way the parties, this can be done. If somebody is aggrieved, one can come forward and disclose all that knowledge. But when we are testing a application of an article of the Constitution, and unlike a statutory provision which is to be looked into, whether that kind of incisive examination required to arrive at a finding that we think that something more is required and to be laid down. But the one specific, very interesting aspect on the independence of judiciary angle came in, on the tenure based. In 2017, the Finance Act 2017 came and multiple tribunals were merged. One very important departure was that unlike in the respective acts, the tribunals were provided, the date of retirement was 62 years in some case, 60 in some cases. In 2017, the Finance Act said that 5 years is there and there is a provision for reappointment. The first act was not there, it was amended 2017 came. One of the argument was raised in Madras Bar to say because the tenure is 4 or 5 years and you have a power to reappointment, you can keep control over him. And therefore, independence of judiciary is affected, relying on all those case laws. Court examined this position, looked into this aspect and said that instead of 5 years is the relevant period. The 5 year has been subsequently been a new act. We made 4 years. That's also under test today, which is coming up before the court. But so far as to look at a very important factor of a tenure and very important factor of a reappointment, which is to be made by that, is it to be pitched to a level to say it is going to affect the independence of the judiciary and consequent functioning, these quasi-judicial or judicial tribunals which are going to function, is to be raised at level? The court said nothing that can't be done. And one very more interesting aspect was also noted by Justice Nageshwar Rao in that is, can anticipation or a threat in future can be basis to declare any law unconstitutional? That was, and these were the words used in that. I can read those paras, I pointed that out specifically. In Madras Bar, which has been there. The court said that this is not the examination. You need to show in a certain instance that as a matter of fact, there is arbitrariness which has, as a matter of fact, has taken place. Those are the instances where we need to look into this aspect, and then only we can act. We can't declare a law unconstitutional based on that there is a threat, there is an apprehension, there is a likelihood which is likely to happen. All these instances which are there, this is may I request if my lords can call for 2026 SCC 1.
2026
SCC page 1.
Page 1.
Page 1. Yes. My lords can come to page 1, 7 in this.
Which para you said?
Para 144. My lords were examining the Finance Act of 2017. Para 144, 145. This is on page 137. May I please? I'm sorry.
Yeah.
Hello, this is Togi got it. Page 137. Please understand. On examining the constitutional scheme, the statute which had created tribunals in the precedence of this court, laying down attributes of independence of tribunal in different facets. We do not think that the power to prescribe qualification, selection procedure, and service condition of members or the other office holder of the tribunal is intended to vest solely with the legislature for all times and purposes. Policy and guidelines exist. Subject to aforesaid, the submission of the Learned Attorney General that Section 184 was inserted to bring uniformity and a view to harmonize the diverse and wide-ranging qualification method of appointment across different tribunals carries weight and, in our view, needs to be accepted. 145. Cautioning against the potential misuse of Section 184 of by the executive, it was vehemently argued by the Learned Counsel for the petitioner that any discretion by the executives of such power threatens and poses a risk to the independence of the tribunal. A mere possibility or eventuality of abuse of delegated power in the absence of any evidence supporting such claim cannot be a ground for striking down the provision of the Finance Act 2017. It is always open to the Constitutional Court on challenge made to the delegated legislation framed by the executives to examine whether it conforms to the parent legislation and other laws, and apply the policy and guideline test, and found contrary can be struck down. Well, as I understand, this is a delegated legislation. So, but the question again is that can a potential threat can be a ground to say that some action is required? And second, the rules of the procedure, which whether it's a selection appointment, can only by virtue of a statute which should be provided. And these high functionaries which are operating in the functioning of the electoral democracy in the country, which is functioning fine, where the institutional setup prevents or provide a check that this should not be abused. In that case, should it be treated as there is a vacuum or a gap where the court required to step in? That's my respectful submission, the question which requires consideration by the law.
Since you activized us on this judgment,
yes,
we'd like to make use of the opportunity to just ask you to read para 200. 201 and 218. The Attorney General and Solicitor General are also here.
Yes,
it's an opportunity for us to just ask you this.
So let's
page 200.
Para
200, page 165.
165. Yes.
Presently, there are 24 statutes, and it comes to 24 such statutes. And then paragraph 201, you may read.
Please, no, I will start with 201. Such statutory appeals that take away the inherent ability of the Supreme Court, as envisaged in the Constitution, to regulate cases before it by confining its consideration to cases involving most egregious of wrongs and or having the greatest impact on public interest.
And now you read para 218. 218.
218.
172.
Yes. It is apparent, that's how it's done. It's apparent that the legislature has not been provided with the desired assistance so that it may rectify the anomalies which arise from the provisions of a direct appeal to Supreme Court. Considering that such direct appeals have become serious impediments to the discharge of constitutional function by this court and also affects access to the justice for citizens, it is high time that the Union of India, in consultation with either the Law Commission or any expert body, revisit such provisions under various enactments provided for direct appeals to the Supreme Court against the orders of the tribunal, and instead provide appeals to the division bench of the High Court, if at all necessary. Doing so may merit benefit in addition to the increasing and affordability of justice and more effective constitutional adjudication by this court. It would also provide an avenue for the High Court judges to keep pace with the contemporaneous evaluation in law and hence enrich them with the adequate experience before they come to this court. We direct that the Union undertake such an exercise expeditiously and preferably within a period of 6 months at the maximum and place the finding before the Parliament for the appropriate action as may deem fit.
Has anything been done? The November 19, 2019 judgment date.
Yes.
Something is going on, my lord. It's my vague recollection But the problem, my lord, this is again from my recollection I'm saying, the problem is the statute provides that the tribunal, some of the tribunals would be presided over by
Supreme Court judges.
by a former judge of this honorable court.
That is a
And thereafter, appeal going to the High Court, my lord, doesn't appear to be. But my lord, that logic may perhaps not be a correct logic for the simple reason that a former honorable judge of this honorable court, if delivers an award in a, say, 10,000 crore arbitration
go to the district court.
to the district court also.
Exactly. So that we don't know why.
I'm sorry.
On a daily basis, we encounter this. That's why we ask you.
It's a very.
My understanding, there is no
parallel
problem.
to- I'm sorry.
Whether the award is by the Chief Justice of India or somebody else.
No.
It has to go to a forum and not prescribed.
Competent. That's what
It's not prescribed. Merely because it goes to a district judge doesn't mean that the Chief Justice of India award is being overruled. No.
No, it's the
It's a mechanism.
award, my lord, which is.
It's a mechanism. It's authored by Chief Justice of India or this court.
That's exactly what he's saying. Therefore, the order of the tribunal can also be appealed.
Yes, that's exactly what.
Whatsoever man by it, he might be a superior in this court.
This court should be now. This court is dealing with this case. These are the cases, kind of cases we should be giving.
Your lordship should be hearing. Yes. But this has to be a constitutional court in real sense of the term.
Absolutely.
And my lord, there can
And
be.
that's why it's rightly said. Before coming to this court, you are never a patient to deal with.
Right.
And for the first time, through the these appellate tribunals, which is our expertise, people are there. Now coming traveled straight over to this court.
We don't know what your action.
I only want my only add on. I just want to stop the floor.
Mr.
The anxiety.
Just 2 minutes. He wants to say. Yeah.
The anxieties which are again shown in para 2 and 5 is that the nature of the jurisdiction of the court and its position as a constitutional, deliberator. If that is going to be anyway diluted, it's going to be affected, then why flood the Supreme Court with kind of appeals without
Not
internal
contemplated by the founding fathers.
without internal assistance? Not only here, even in the US. There are several instances where statutory appeals go directly to the US Supreme Court. I can give those instances. I'm not giving a comparison. But then the point of concern is without anomalies which arise from the provisions of direct appeals. Therefore, the direct appeals, if they are mechanically worded, one statute replicated like that, then there are some anomalies even in the consideration by the court as an appellate court, a second appeal, section 100, all that. Notwithstanding all that, could be anomalies. That is where the anxiety of the court is supposed to be.
That's right. We are just pointing this out. When Balbir Singh pointing it
Therefore,
out.
for example, my lord, in the CAT, your lordships are aware.
Correct.
It goes directly to the division bench of the High Court.
That's why, because judgment of this court.
As I said, the takeoff is there is a matter which requires your attention. There is a trigger point. There is something which is happening. That's where 218 comes in. So we are all coming back on the same wavelength.
We'll raise. We can.
Mr. Balbir, only one question to you.
Please,
You have cited the judgment of the Delhi High Court,
yes,
the CAG,
yes,
and you have asked us to go through this paragraph 14,
yes,
41, which you quoted last.
40.
But if you go to this very paragraph,
Yes,
there is a mechanism in place, which was placed before the court, and court has noticed it. If you come to which page you are referring to,
well, this was on page
Roman 5, the other decision.
The decision, yes.
If you read it downwards, there was a mechanism in place.
Well, this is a convention. That's what we call convention.
That's why we are requesting you.
Yes.
What is the mechanism in place in your case? You see, if you go downwards, last paragraph, in our view, there has not, respondent number 2 is appointed following, you got it?
Please,
Following a time-tested convention, and the test is there.
Yes.
We want to know from you, what is the test in place in your case, as here in the CAG?
Well, my understanding is that this is what we call convention, but
God knows, we
post
check
lunch
it.
will answer this question. Post lunch I'll answer.
I'll take some time after. Mr. Balbir.
Lordship is hearing this matter continue.
We continue. We can't keep.
Grateful one.